What happens if someone got hurt and it was obvious whose fault it is, but they died before anybody ever talked to a lawyer about it? Can their family do something? And again, that question comes from Ryan.
Ryan, that's actually a good question. And the answer is yes, the family can do something. I mean, it's called a wrongful death lawsuit in Mississippi. The first thing you have to do is you need to determine who the heirs are and who the wrongful death beneficiaries are. And then you can bring a suit. I mean, obviously, if it's someone else's fault, you're going to be able to prove that through witnesses and other circumstantial evidence. So, but you would need to talk to a really good trial lawyer so that they can put together the things that you need in order to file that suit. Rocky, do you have anything to add to that?
Yeah, and we have to do that all the time. And there's different layers or levels of who can actually recover. And so, if you're married and your spouse dies, then you would be able to recover, and your children would be able to recover. And then if somebody dies without a spouse or children, then it would go to their brothers and sisters and to their parents if still living. What I do see happening sometimes is, say you have 3, 4, 5 siblings and a parent dies and they all want to participate in the lawsuit, but there's one of them that maybe moved out to California or New York and they don't keep in touch with them anymore. And they're like, well, we don't want to give them any money. They weren't close with mom and dad. Mm-hmm. The law says you still have to give them an equal share. And so you can't cut those heirs out under law, even if you want to. And you actually need to give them notice once you file the lawsuit, even if they don't really want to be involved in the case. So just because you don't like them doesn't mean they're not entitled to a share.
Wow.
Right.
Well, thank you for sharing that. And that, I'm assuming that's the same case if, let's say, if a loved one passes and the children find out that there were other children that maybe they didn't have a relationship or their first time getting to know. Does that apply the same thing?
Well, it can, and I mean, I actually left out one other point. I mean, when you have a suit, you also can have the survival action, because the survival action may not be the cause of the death, but you can still continue a lawsuit once someone's deceased as a survival. It means that if someone had a car wreck and they were severely injured, and in the interim they may have died of some other cause of the car wreck, they can still continue that car wreck lawsuit under the survival action.
The other thing about asking about if there's other children, we have a pretty old, antiquated statute about how you give notice to the known and unknown heirs. You have to publish in a newspaper of general circulation for 3 consecutive weeks and have a date certain for a hearing. And then the bailiff goes out in the hallway and calls, are there any heirs of this person? Are there any heirs? 3 times. And if nobody answers that call other than the people in the courtroom, then the court can judicially determine these are the heirs. And somebody could get cut out that's a real heir because they don't get noticed. I think the legislature may want to address what's reasonable notice and maybe move into the modern times and try to use the internet, because people don't read the newspaper like they used to.